Andrew Metcalf is an employment lawyer at Ogletree Deacons. He represents businesses and public organizations in all aspects of employment law, including both litigation and human resources advice. He assists clients facing lawsuits and administrative charges alleging employment discrimination, harassment, retaliation, and violations of other workplace laws and regulations, including FMLA and FLSA. He has guided clients through investigations by the EEOC, Missouri Commission on Human Rights, the Department of Labor, and OSHA. Having extensive experience with complex employment litigation, Andrew offers strategies to ensure clients are efficiently and thoroughly protected in workplace legal matters. He's also very involved with the state SHRM and local SHRM in St. Louis, so he works with us HR folks all the time. So please help me welcome Andrew Metcalf.
All right. Well, thank you guys so much for having me. This has been really, really fun to be here this morning. And before I begin talking about anything employment law related or myself or the fun things that we're going to chat about together today, I want to make sure that it is lost on none of us in this room how special it is that Connell Insurance takes the time to put this together, as I understand it, not just today, but 3 times a year. And there's a reason I say that. I had no idea who Connell was before this. They did not pay me to say this or anything like that. This is from the bottom of whatever heart I have. And I mean it because my firm does these conferences too in Kansas City and in St. Louis and our other 50 some odd offices around the world. And the reason I say it's special, I'm going to tell you a secret that no one wearing a Connell badge is going to tell you. There's really no direct benefit to any of us who do these conferences for you. To us as companies, right? We make our money other ways. This is totally something selfless and altruistic. So I think it is really, really great that Heather and the whole Connell team take the time to get away from their business and put this on for you because, again, they don't have to. But with this kind of stuff, we can be so much more educated about the issues we're facing in the workplace. So how about a round of applause for all the folks with Connell name tags? So, as you heard, my name is Andrew Metcalf. I am a lawyer focusing on employment and workplace and human resources issues. So I do 2 things to make sure you understand the perspective that I come from when I talk about these issues. Number 1, I defend companies in court when things don't go well and someone decides to bring a lawsuit against you for whatever reason. I am one of the folks who will defend lawsuits like that in front of the administrative agencies like the EEOC and in court. The second thing I do is exactly what you see here. It's training and advice work to make sure that we're as educated we can be about best practices and what we need to do to hopefully, as best we can, avoid ever ending up spending a week in trial with me, which is a lot of fun for me and 0 fun for you. Or if we're forced to do that, if we have no choice, then hoping we're as set up as well as possible. So I love talking about these issues. We'll talk about whatever you guys want today here in this widest conference room that I've ever spoken in my entire life. Congratulations to Branson on winning that award. That's not an accolade that I knew Branson had from the last time I was here, but now we all know. So I'll try to give equal attention to both sides of the room, but hello to each of you on the ends here. So I want to begin by telling a story, and that's the story of a law. The story of anti-discrimination laws in this country. Think about how far it's come and where we are today versus where we used to be, and think about where we're going next. And this dovetails perfectly off of Jay's presentation. I was talking to him about a minute ago. But really where we began was in 1964. When there was rampant discrimination in this country. Depending on how you looked, you couldn't buy things at certain stores, you couldn't walk into certain buildings, you couldn't sit at certain lunch counters, you couldn't use certain bathrooms or water fountains. We passed Title VII to fix that, and it added a bunch of protected classes and said you as employers can't discriminate against people in hiring or in employment or in termination decisions with respect to the protected classes that were in Title VII, which was originally just a few: race, color, religion, sex, and national origin. Those were the original ones. Fun little side story for all the women in the room and who work in HR and in your organizations. Discrimination based on sex originally wasn't going to be added to Title VII. It was put in the last minute, just a few days before the bill was passed, and not by someone who was really trying to advance the rights of women in the workplace. It was passed by someone who didn't want a law prohibiting race discrimination. So he wrote in, well, this law, if you pass it, will also prohibit discrimination based on sex. And he thought for sure that that notion would be so crazy to the world that surely they wouldn't pass this anti-discrimination law, because, you know, who wants to give women equal rights in the workplace? And thankfully, the law did pass, and today we have some really important protections for all of us in this room and all of our organizations. But it didn't have everything in it. A couple years later, they started saying, well, you know, maybe we should protect older workers in the workplace, right? You can't fire someone because they're old. So they passed the ADEA to prohibit age discrimination in the workplace. Fast forward about 20 years, we start thinking, you know what? Maybe people with disabilities should have those same rights too. So George H.W. Bush signs the Americans with Disabilities Act to give people with disabilities equal rights in the workplace. And think about it. In 1990, what are we thinking about? We're thinking about the fact that there are workplaces and buildings out there with a couple steps to get in the door, without ramps, without literally ways for people to get into the building. These were the main concerns when we first started thinking about how to make the workplace accessible for people with disabilities. Now, a lot has changed since 1990. Today, we're worried about a lot more issues and whether we need to accommodate people with disabilities by tolerating different things in the workplace. So I think we should talk a little bit about medical marijuana. And based on the timeline that Jay gave earlier, hopefully next year at this, the baked goods that Connell Insurance offers, I guess, could be a little bit more fun for everybody. I had a bagel this morning. I'm not impaired, I don't think, so I don't think they're getting ahead of themselves on the law. So this is coming with a vengeance. I'm from St. Louis. Illinois has recreational marijuana coming, which means it's going to be everywhere. So this is really something that we have to be ready for and think about how we're going to deal with it on a case-by-case basis. And as a company-wide policy, when these issues come up, depending on what's right for your particular organization. Service dogs. Service animals in the workplace. You've all seen maybe an article now and then about an emotional support peacock not being allowed onto an airplane. Well, what are the obligations for you as an employer to allow someone to have a service dog in the workplace? What about me? I work a lot, so I can't own a dog, so I'm a proud cat owner. I also have another cat. So you know, what about me? Do I get to bring my cat to work now because, well, he, I guess, relieves stress? I don't think that's actually true. And finally, just technology, working from home, all sorts of different ways that we're changing the workplace in general. The questions that we have to face are, what are the circumstances when we're required to do that? And when are we not required to do that? When do we want to do it? And when do we want to say, you know what, no, that doesn't work for us, and we don't think we legally have to do it? So this presentation's on the top issues of 2020. I am happy to talk about and review whatever it is you want to. That's why I'm going to pretend this slide is blank. I'm not going to pretend that it's because I planned on going back and finishing it later and then didn't do it after I finished the presentation. I'm happy to talk about whatever you all want. But the reason I wanted to focus on ADA, not knowing that Jay was going to tee it up really, really well with his presentation, I swear, is because this is one of the biggest issues I see us facing as HR managers and as business owners day to day in our workplace that creates legal risk. That's one of those areas where we make decisions that we think are right and seem right, but may not be made in the best way or may not be documented in the right way for us, so that we can avoid, as best we can, having problems later on. So that's why I thought we wanted to talk a little bit about ADA compliance today, because again, it's one of those issues that is one of the most difficult to deal with in the workplace, and that clients call me about more and more. And as I was talking over email with Heather about what I should talk about, they said the exact same thing, is that they are getting a lot of questions about how to comply with these laws. When are you required to reasonably accommodate an employee, and when are you not? And I want to start with something, again, I'm going to piggyback off of Jay's good talk a lot, because he teed up a lot of these issues really, really well, and that is what is a disability under the ADA? I want to talk about what a disability is first under the ADA because it's something Jay brought up. And there's a difference maybe between what the law defines as a disability and how you're going to treat things as a disability or not in the workplace. Disability under federal law has a really confusing definition. It's any impairment that substantially limits any major life activity. Major life activity is defined as pretty much everything you do day to day, from working, sleeping, eating, anything else. So a disability is some sort of medical condition that substantially limits a major life activity. Now, over the course of 20 years, courts started really breaking down that definition of disability and saying, here's an example. They'd say, you know what, okay, this person has cancer, right? And let's look at this. Okay, they have to go in for chemotherapy, and it affects them for 1 or 2 days, and after that, they're fine, right? Or they feel a lot better than the first 2 days of chemotherapy. And courts started saying, you know what, we don't think that counts as substantially limiting. It just doesn't make sense to us. I mean, this is something that's got to be permanent, like being in a wheelchair or something of that nature. So courts started narrowing that definition of disability. And as a result of that, Congress started looking at it, and they did something that we rarely see Congress do, which is they passed a law. Believe it or not, that's their job. I'm not sure if anyone knew that, but that's what they're supposed to do, according to a Schoolhouse Rock video I saw like 25 years ago. So I know this is really high level. If anyone's not following, I'll be here after for questions. But so in 2008, Congress came together and said, look, we want to expand the definition of disability under the ADA so that it covers everybody with cancer, so that it covers more people. And as a result of that, we're in a situation now where even 10 years later, courts are still answering the question for us, who's disabled and who's not. 15 years ago, it would have been a really easy answer. Someone breaks their arm, no, that gets better. Right? It's going to get better after a couple months. They're going to be in a cast. They don't qualify for protections under the ADA. Today, there are cases starting to say, you know what, that broken bone's pretty bad, and at least for a little amount of time, it's going to count as a disability. So what is the advice that employment lawyers are giving to folks as a result, and business owners, as a result of that expansion of the definition of ADA? I always say, let's kind of assume the person might be disabled. Don't make a decision on that. But let's go through that interactive process. When they present you and they're asking you for something, I want this in the workplace, or I want that in the workplace, whether it's medical marijuana, a service dog, coming in a little bit late, let's assume for a minute that they have a disability and just ask ourselves, is this something that is reasonable for us to provide in our particular workplace? And let's go through the analysis. And the reason why I say that, the reason why that's my advice, is because I'm happy to litigate whether someone had a disability or not, right? In court, in front of a jury, that's fine. But do you want to be doing that? I'm not so sure. I'm not so sure that that's a decision that you as a business leader want to be making, whether someone has a disability or not. So my advice is skip the first step. And really the EEOC regulations really suggest this. Skip the first step. Don't worry about whether or not the person has a disability so much as the second question of, is it reasonable to give them this thing or not? Now, that's not always the case. And we'll talk about situations when we're going to push back on that in the workplace and when we can push back on the doctors to ask, hey, is this really a disability under the ADA? But that's a general tip. This slide has a lot of people on it because a lot of people in this country qualify as having a disability. And the special thing about the ADA that you need to know, most of the anti-discrimination laws that I told you about at the beginning, they prohibit certain conduct, right? They say you can't refuse to serve someone because they're black or because they're white or anything else, right? But the ADA, and actually Title VII's religion protection, are a little bit different. The ADA says that you as a covered business owner have an affirmative obligation to provide reasonable accommodations to people with disabilities in a way that enables them to do their jobs. So think 30 years ago when this law was passed, it was easy, in a sense. It was obvious what we needed to do. If someone needed a ramp to get into your building, you had an obligation to build that ramp and make sure that they had the same equal opportunity as anyone else to get into your building and work. So what is a disability, though? It could be anything. Today, we're not just dealing with the obvious disabilities that you can see. The unseen disabilities are the ones, Heather and I were talking about this a little over email. We worry about you guys that we're overlooking when a disability is unseen, whether it needs to be accommodated, because it could qualify under that definition as substantially limiting, even if it's something that you don't really perceive, right? So Jay gave the example of PTSD. The doctor diagnoses someone with PTSD, that's almost always 100% of the time going to qualify as a disability under the ADA, because in many ways, PTSD substantially limits how the person performs major life activities. Other examples, sleep apnea, anxiety disorders. Now again, we can verify whether employees actually have these things by sending the right medical certifications to doctors. So I have forms that I give to clients. I'm happy to give to any of you if you give me your business card after, that sometimes I say, hey, let's send this to a doctor. The person's saying they have this problem, or medication causes them to be drowsy in the morning, and that's why they've been late. Well, we don't know. Let's get their doctor to say that. That's a little bit of extra verification that we can use to make sure that we're doing the right thing, because with unseen disabilities, how do you know whether they have one or not? Have a medical professional certify it, and you can do this under the ADA for things that aren't obviously disabilities. Have them certify that it qualifies under the definition of disability. So the forms that you should use, and now I know there's going to be like 10 million people in this wide room giving business cards after this, which wasn't my intent of that, but I'm happy to take them. But the point is that we can go through that process and have a form that we give to doctors that says, hey, can you explain to us how this is substantially limiting? Can you explain to us how it affects the person? Can the person still perform these particular really important functions of this particular job that we have? So particularly with invisible disabilities, I say, let's go through that process. Let's make them verify. You have to do it every time. If someone had a car accident, is in a wheelchair afterwards, it might be a little draconian to say, oh, well, I really need a doctor's note before we'll install a ramp, right? Because it's obvious. The EOC is going to love you guys if you do that. They'll be knocking on your door. You'll be their best friend. So you don't always need to do it, but on a case-by-case basis, that can be a tool that we use to help with compliance, but also meeting the business goals of make sure we are granting legitimate accommodations when necessary. So remember, you need to provide those reasonable accommodations to the known disabilities of individuals in the workplace, absent undue hardship. The undue hardship standard is extremely difficult to meet. You have the burden of meeting it. It's really something that I would reserve for small businesses most of the time, when something would be extremely costly and you're being asked to do it, or would really get in the way of a person's job. Now, you might be asking yourself, okay, Andrew, so can anyone just come into my workplace, or can I go into my workplace and say, I need this, that, and the other thing, and then do they get it? Absolutely not. So here's some other rules that you need to remember under the ADA as we kind of get this 101 before we go into the tougher stuff like medical marijuana and service dogs. Eliminating an essential function of any position is not necessary. You don't need to do it. So if someone comes in and says, unfortunately, I have this disability, and it causes me not to be able to do X, if X is so key to their job that it's really pointless to have them working there anymore if they can't do that, then you don't have to grant an accommodation that would just eliminate that function. Now, on the other hand, there are marginal functions of the job, right? Ones that aren't essential. Those you might need to grant an accommodation that would shift those to someone else. So here's an example. There's so many good ones, but this gets litigated in court a lot, whether something is an essential function or not. And in these slides, I'm going to give you the factors that I want you to go through when you're making the decision about whether something's an essential function. But here's an example. A woman worked in a nursing home. She cut hair. She had surgery. After the surgery, the doctor said she can no longer push anything over 40 pounds or something of that nature. The employer looked at the job description and said, oh, well, nope. Part of your job is pushing people in this nursing home from their rooms to where you cut their hair. So that's listed as an essential function. As a result of that, you can't do your job anymore as a hairdresser. That's an essential function. We say it is. So because you can't do your job as a hairdresser anymore, you're welcome to apply for other positions, which is another type of accommodation, moving people to other jobs. But it's the accommodation of last resort. It's the one we should go to last. Everything else fails. So they said you can apply for other jobs, but you can't be a hairdresser anymore because you can't push people to and fro for their hair appointments. Believe it or not, she didn't find another job. Is that surprising? She's a hairdresser. What else is she going to do in a nursing home other than chop hair, right? So she, believe it or not, sued, and it went very, very well for her. Just put it that way. Why did it go very well for her? Because when the court analyzed this, and Jay knows just as well, what are we going to do? We're going to be breaking down minute by minute what she's doing day to day. You're going to love us again. We're going to be your favorite people. When we are literally walking through your facility and figuring out what does a hairdresser do minute by minute, I will time how long they're there. I'm going to time how long they are pushing chairs. That's what the employee's attorney did, and it turned out to be like 1.5% of her day that she was pushing people to and from where she would cut their hair. And as a result of that, the court looked at that and said, how can you call this an essential function of her job to push people to and from? I give this problem to students that I teach at WashU and say, come up with other accommodations. And as you probably can sitting there, it's really easy. What's some accommodation we could give her? Let's get some audience participation here because I need to drink some water. One over here. Have her go cut the hair in the room. And believe it or not, guess what? She was already doing that for some people. She was already cutting, because some people couldn't get out of their room easily. It was easier to cut them there. Have them go cut in the room. What's another accommodation? Come on, this side of the room, step it up. Sherry up front. Have someone else push them to and from their room. How long do you think that would take? A couple minutes, right? Wouldn't have been nothing. But we get in this thing where we say, no, that's your job. You've got to do that. You've got to be the one. And that's when we get into troubles, when we have that knee-jerk reaction. And that's what happened here. The manager had it. HR got involved kind of late and wasn't able to help at that point. But what you need to do as HR is making sure that we are rolling up our sleeves, is the analogy I use a lot with clients, documenting these situations right, and making sure that we are exploring those accommodations and taking the initiative to make sure that we are taking care of these people and not putting them in a limbo in between jobs such that they don't have any opportunities going forward. So what are potential accommodations under ADA 101 still? Modifying the job, modifying the way things are done, modifying schedules. Changing someone from full-time to part-time could be an accommodation. Giving someone time off is an accommodation. Whenever someone is really, really having an issue, and you see that, you might have to give them some time off if they can't perform the essential functions of their position. Quiz question. How much time do they get under the FMLA? 12 weeks, 480 hours, right? Can you hear me now? You guys hear me? Is everybody good? All right. I can yell if you want, but 12 weeks of FMLA leave, right? So we need to make sure that we're giving those 12 weeks of FMLA leave. But what if the person comes back or doesn't come back, and at the end of 12 weeks of FMLA says, you know what, I need a little bit more time? What kicks in? What law? Give you a hint, it's the one we've been talking about. Thank you up front. It's the Americans with Disabilities Act. You've got to go through that reasonable accommodation process as they're coming back to determine, are there any accommodations that will get you back to this workplace? And if not, number two, how much time do you need? Because I need to analyze whether or not it's going to be a reasonable accommodation to grant you that time, and I need a doctor to sign off and say how long it's going to take for you to come back. Heather and I were talking about this before I presented. One of the biggest issues we see is that knee-jerk reaction. Somebody ends FMLA, and they say, I can't come back. And they never say when, right? I would never say when, right? I don't know. Like, I'm sick. I don't know when it's going to be better. But you need to get the information as best you can about when they can come back. What we know is that people always ask, clients always ask, how long is it reasonable to give them time off, right? A week, a month, a year? And the answer is, it depends, which is why Jay and I get paid a lot of money to do what we do, is giving answers like that, right? No, but in all seriousness. So it depends, and you need to go through an analysis of how exactly it would be reasonable or not to leave that position open. What we know is that an indefinite period of leave is not reasonable under the ADA. So when I'm walking through clients this, they always call me like the Friday at like 4:30 when they want to terminate someone. And they tell me the whole story, and they're like, can you please just rubber stamp this so that my boss doesn't get mad at me, and I can say Andrew rubber stamped it, and I'm going to be like, yeah, no. But so they, you know, I hear a lot, hey, so we can't get information from them or their doctor about how long they're going to be gone. Well, in the communications that I help clients draft for doctors, and what you should do is try to get to a point where the doctor either tells you it's going to be this amount of time, or it's going to be indefinite. I can't say. Because if someone is asking for indefinite leave, we're pretty safe in concluding that they cannot perform the essential functions of their job anymore, right? We're pretty safe to say that we need to replace this position. You are more than welcome to come apply for us when you get better. Our hearts go out to you. I put that in every letter I write like this. Our heart goes out to you. We're thinking of you. We're praying for you if you want to, whatever you want. And say, you are welcome to come back, but right now we need to find someone to do this particular job. So you need to go through that process and think about whether leave is a reasonable accommodation. If no other accommodation works, if the person just can't perform the essential functions of their own position, you've got to look at the accommodation of last resort, which is, are there other positions that they could do? Is there something else open in your organization that you could place them in? And my recommendation to you is that you document all these things that you're doing like a diary. When you're having discussions about it, who you're talking about it with, the analysis that I know you're going through, that I know you spend a lot of time thinking about. Because if there's a lawsuit over this, that's going to happen maybe 1 or 2% of cases. An ADA situation leads to a lawsuit. Most of them you deal with and it's fine, right? But every now and then it leads to a lawsuit. And 1 to 2% of those lawsuits go to my favorite part, your least favorite part, a trial. And I've had this, ADA trials. And we're going to be sitting there arguing about whether something was an essential function and whether you should have granted an accommodation. And how long is it going to take for that lawsuit to go to trial? Come on this side of the room. Nobody knows? Oh, give me a guess, though. Forever? Okay, that's close. I don't know. Anybody? Come on. Months? Years? 5 years? Who wants to take a guess about the oldest lawsuit that I have right now? How long it's been pending? 2 years? 10? 7 years. It was a termination in 2012. For the record, I did not begin with this case. I wasn't even a lawyer yet when the person was let go. I was still just sitting in my second year at WashU Law School. But we inherited it from a couple other firms to take it to trial. They finally said, finish this. That happens in Missouri courts sometimes, that cases linger. If we're sitting there in court 7 years from now, and I'm asking you about conversations that you had about whether something was an essential function, how much of it are you going to remember? Absolutely none. And if you tell me you remember all of it, the jury's going to think you're a liar. And frankly, I am too, because you have the memory of an elephant, right? It's not, you're not Horton Hears a Who. Like, you need to write these things down so that later we can be in court and I can say, do you remember all this? And you'll say, I don't. I'll say, would documents help you? Why, yes, they would. Terrific. I'll hand you your documentation. You'll say, okay, I remember what we were doing here now. On this date, we did this. On this date, we did that. It doesn't take that long to do that kind of documentation. I like to keep it like a diary. When you see an issue with an employee that could go to something later, opening up a document, writing the dates, who's involved, please, first name, last name. You don't want to have to pay me to go figure out what these people's last names and job titles are later. Keep that diary of who, what, when, where, why, and how in these situations so that you can say later, this was the decision we made, and this is why it was a good decision, and a well-reasoned one, and one that we took a lot of time to really try to figure out. So Again, you aren't required to provide necessarily the exact accommodation that an employee is asking for. Say someone asks for X, well, you can come back and say, well, would Y be just effective? Maybe someone wants, they say, I can only work 35 hours a week. And you say, okay, well, you're working 40 now. That's not a big deal. And they say, oh, and I want it off on Friday afternoons. Well, unless the doctor says that they need to take off on Friday afternoons, you might push back and say, you know what, actually the most convenient time for us for you to do that would be 1 hour each day of the week, because that would get you to 35 hours, and your doctor's telling us it's 35 hours. You make those kind of decisions, not the employee. And going through those kinds of analyses are how we make sure that we both protect the rights of people with disabilities in our workplace, which we all should want to do, and on the other hand, make sure that you are protecting the business interests of your workplace. It's a delicate balance, but we can do both if we use these tools in the right way. These are the slides with essential functions. These are the things that you should go through. Job descriptions are really important here. If something is essential to the job, you should have it written down in those job descriptions. I give a whole nother talk about job descriptions that I'm not going to do today. A lot of you who are writing fast or taking Snapchats of this, if I'm going through the slides too fast, I'm happy to send you these so that you can have it afterwards. But essentially, you want to be asking yourself, if you're thinking, you know what, we're going to deny this accommodation because this would just eliminate the essential function of the job, you need to be asking yourself, does the job really exist to perform that function? That's a really safe question to ask. Like, is this thing so important to this particular job that we need to make sure that anyone doing this job is doing that function? You need to go through that analysis, not just what's in the job description. Don't have that knee-jerk reaction of, well, pushing wheelchairs is in your job description, so it must be required. No, think about whether it's actually really important. But don't worry, courts are still, I think, using common sense. Here's a headline from the Fifth Circuit. A security guard liked to nod off, and he said it was due to a disability. Well, the court said, no, that's an essential function. If you're my security guard, you have to be watching those cameras or reading a good book and glancing at them every now and then. But on the other side, here's a pharmacist with needle phobia that she had certified by a doctor. Said, look, this causes me so much anxiety that I can't give people shots. And it is so severe that I just can't do it. And it's a phobia, and my doctor certified it as such. And that's really all the documentation that the employer had on this condition. And they said, look, we think you have to do it, so you can't work in that job anymore. She got a pretty hefty, or he got a pretty hefty judgment against the employer, because in cases like that, they're looking at what's the reasonable accommodation. Well, for a pharmacist in a big store, there are a bunch of different people who can give those shots. So saying one person is going to be exempt from that isn't going to cause the whole store to fall like a Jenga tower, right? It's not an essential function of that particular person's job because it's marginal, because it's not what they spend most of their day doing. And again, if you say to a pharmacist, oh, you know what, we think that's an essential function, go find another job. Do you think a pharmacist is going to find another job in a retail setting? Okay, sure, I'll be a cashier, or I'll stock shelves. No, they have student loans to pay off, folks. So they're not going to do that, right? So you get into that problem where transferring, isn't going to be a good accommodation for this person, and not something that we should jump to too quickly. Can we talk about marijuana a little bit more? No one wants to, we don't have to. I did not bring any. Don't ask me how to get it, although, I live in St. Louis. We're in Illinois. They're legalizing it recreationally, so we are getting into a situation where it's going to be rampant in St. Louis, I think. But the question is, and Jay really teed this up. I didn't know how well you were going to tee this up, Jay, but it's perfect. The question is, how does this affect our workplaces now that this is coming to Missouri and so many other states? This is a map that shows, and you can get this off my firm's website, all the states in light green have decriminalized marijuana for medical purposes for cardholders. States in dark green are going recreational. So you can see this is something that originated on the coast, but is slowly but surely making its way inward. So now we have a situation where every time I present, this map is a little bit greener. So it is something as employers that we have to be ready for, including and perhaps especially in the accommodation context. Before we talk about medical marijuana, and because I need to take a break to sip water again, does anyone have any questions about the ADA 101 stuff that I went over? Let's go right up front. So the question really is, I think, and you phrased it as reverse discrimination against people, other people who are non-disabled in the workforce, right, or have to do the job for them. And the question is, and especially about morale, right? Like when you're giving someone something that seems special and different, especially something that might make the job a lot more favorable, we have major concerns about the morale of other employees who have to pick up that slack, right? Who have to do that work and look at that person and say, hey, like, oh, they get something special because they brought in a doctor's note, right? So how do we combat that? There are a couple different ways. Number one, going through that medical certification process to see whether it's actually necessary. Make a doctor say it with specificity. A lot of times the doctors will say whatever we as patients want our doctors to say on those forms. That's the truth of it. Because they have obligations to their patient. If their patient is telling them, I need something medically, and this is what I'm experiencing, a doctor doesn't want to question that, right? For good reasons. But going through that medical certification process to get with specificity, and you'll see in the medical certification forms that you can use, it asks questions about whether the accommodation is necessary for that particular job. How exactly is it going to help enable that employee to do the essential functions of their job better? Asking those questions can really get you to a point where you might say, we're not convinced that you actually need this, or we're not convinced that giving you something else might work just as well, and it works better for us, and we don't think it's going to decrease morale. So the example that I give for this exact question is an employer who maybe has rotating shifts for weekends. Believe it or not, people sometimes don't like working on weekends. And believe it or not, some employees come in and say, hey, I have a medical condition, and as a result of that, I can't work this weekend shift, right? They say, you can schedule me Monday for Friday, but you got to take me off that rotating schedule because of this or that other condition. Well, that's the kind of thing where I would say we need to look at that really, really closely. We need their doctor to explain to us in writing exactly why that is. And then we have a decision to make. Is it an essential function for them to work that weekend? And you need to really go through the analysis for your particular organization about whether what you're exempting them from is an essential function or whether it's not. So in the case of working for weekends, I would say we look at how important is it that everyone work weekends? And there are a couple court decisions that have analyzed this. And they've said, you know what? In these particular employers, nobody wants to work weekends. They've got evidence of that. They've got evidence that morale's going to go down if they exempt people from that schedule. You know what? We don't think it was a requirement that that employer take away the weekend work because that's an essential function of that particular position. So that's a situation where the accommodation would lead to morale issues. We know other people are going to say, you know what, we're not happy about the fact that this person got out of this particular function of the job. But if we go through the right analysis of what the essential functions are, we might find that it is so important for our particular organization that this person participate in that rotating shift schedule that we can say, no, we're comfortable saying that you're required to do that as an essential function. Would I want those things in your job descriptions for those positions? Absolutely, right? And I would want to explain why it is so important and explain to this employee why it is so important. I don't want the email that just says, hey, you're required to work this, that's the job, sorry, period. Send. And I see those emails a lot, right? Emails, none of them confidential unless they're with an attorney. When I'm doing cases, I'm looking at every single email because we're talking about 7 years later at trial. You're not going to remember everything. Your emails are good documentation. But you need to make sure you're going through that analysis to make sure that it's really something that you need to grant. But the ADA does require us to take some sort of affirmative obligation for people with disabilities. a really hot issue right now is whether a person with a disability, say they can't do their current job, are we required to place them in a different job without considering any other applicants if the person with a disability is qualified for it? Are we required to say you get it if you're among the most qualified? And it's a really thorny issue. And courts are going different ways on it. But when I'm talking to clients about that, I'm walking them through, okay, who are the other applicants? How do we analyze this? How qualified are they compared to the person who you want to hire? And how do we weigh that in their particular situation? Does your policy say we generally hire the most qualified person for the job? Because if you do, then you might be golden. Do you have a CBA if you're a union environment? So things like that can help us reach the conclusion that certain aspects of a job are essential functions and that we can't exempt someone from performing those particular functions. So that can be really effective in doing the just thing for your workplace, but also making sure that you're treating people with disabilities as they should be. Now, once we deny that accommodation, the conversation doesn't stop there. You keep your sleeves rolled up because you need to continue talking to that person about what you can do to make this workplace accessible to him or to her. So that's the biggest thing that I see is we say, no, you can't have that. And the conversation stops. What I love to see and what I help clients do is say, well, we're not sure we're comfortable with this, but here's 3 bullet points of ideas we came up with that we think would work for us and be just as effective for you. Can we try this out? Can we see if it works? Can we see if this makes the workplace accessible to you? Because also we think it's going to help us meet our business goals, right? So we can hit those 2 dual things. But of all the slides, these 2 are the ones that I think we ignore the most in our day-to-day jobs, and that I would encourage you to pay attention to as you're going through that reasonable accommodation analysis, so that you don't end up in a situation where you're pushing work off onto other people that shouldn't be. Again, if it's essential work, it doesn't necessarily need to be pushed off, but I want to make sure that all of you are really carefully deciding whether it's essential or not, and you need to do that because your managers don't know any better, right? They're going to say, no, this is how we've always done it. This is what we require. This is how the job gets done here. You need to say, you know what, in your head, the ADA sometimes requires us to change the way that things are done in the workplace. I can't tell you how often I'll get a lawsuit from a very well-meaning small business, and they say, well, we didn't grant an accommodation because our policy says this, that, or the other thing. And I say, well, the whole point of the ADA was that it changes how we apply our policies in the workplace. It was supposed to change that answer to, our policy says this, but in your case, we're willing to do this, that, or the other thing because we think it's a reasonable accommodation to allow a person to do that. Another area this comes up a lot is religion, which is never a charged topic, so glad I brought it up. Religion, religious rights in the workplace, we all have them. Under Title VII, we are all very lucky to have the right to get reasonable accommodations to practice whatever our religious belief is. And that's a really important right. Again, it's one of those affirmative obligations under under Title VII. So I gave the example of someone who might need off one day. Well, a lot of people practice their religious beliefs when? On weekends, on a Saturday night, on a Sunday morning. It might be a reasonable accommodation to give the person that time off so that they can practice their sincerely held religious belief, even though you have a policy that says everyone rotates shifts on weekends. You have to go through the analysis to make that decision on a case-by-case basis and not just have that knee-jerk reaction of, no, we're not going to let you practice your religious belief on a Sunday morning because we believe that you have to be here, right? You've got to go through the analysis is the point in each one of these cases and really think about what's essential and what's not. Thank you for the question so that I could have water, which I kind of want again now, so I'm going to take one more from this side of the room if you wouldn't mind. The question was, look, ADA, we think of it as permanent disabilities. What about temporary things, right? Look, there are some things that are so easy for us to say aren't going to be a disability. the common cold is a great example. The flu, perhaps, is a great example. But can we just say, oh, it's not permanent, so we're not going to treat it as a disability anymore? Probably that's not the safe way to go. Again, I tell a lot of clients, don't make any decisions about whether someone has a disability or not. Just skip that question and just go to, okay, assuming it's a disability, what do you need? What are you asking us for? Because maybe it's something we can give easily, maybe it's not, and then we need to ask some more questions. So, because there is the possibility that a shorter thing is going to be constitute a disability by a court. I would rather fight that for you in court later than you fighting it day to day, unless we need to send those doctor certifications. So again, I'll give the same answer that Jay did, that I know people love getting at these seminars, which is this is playing out as we speak. There are a lot of cases out there that are deciding what's a disability and what isn't. And here's the reason I tell you that you probably want to skip to the accommodation question, is because, as Jay knows, it's a lot harder to get cases dismissed than you would think. And that's really annoying on the defense side. Because when you guys go for jury service and you're listening to us talk, you think, oh, there must be something to this case. The judge didn't throw it out. Well, in a lot of situations, it's pretty easy to get to a trial if you want to. People have a right to that in this country. And so, you know, we'll submit at some point in the case all the evidence about whether the person has something that constitutes the definition of disability or not, and the court will say, you know what, this is all great. I think it's for the jury to decide. I think it's too close a question. So I'm going to let a jury decide whether someone's severe anxiety, for which they had certain prescription drugs, is a disability. Another really interesting case that came down, a guy had a broken leg. 10, 15 years ago, lawyers would have stood up here and said, no, that's not a disability because it gets better, not in any easy way, as anyone knows, but it's going to get better. It's not going to be substantially limited. It's not exactly what you said. It's not going to be permanent. In this particular case, though, the judge said, you know what? This wasn't just a broken leg. This was like weeks in a hospital. This was, you know, major surgery. This was trips back to the hospital. This was a lot of different medications. This was an infection at one point. This adds up to substantially limiting, I think, but let's let a jury decide. You guys go argue it. And do you think it's fun for me to stand up there and say, hey, we fired this person, but it wasn't a disability? It's a hard argument to make. I've done it. But the point is, instead of having that reaction of, well, it's not permanent, so we're not going to accommodate it, it's a lot easier to win cases later on based on that second question. Whether you engaged in that interactive process to try to figure out whether there was a reasonable accommodation that could be granted. Courts and juries look at what we're doing in that process. And if you show that you were diligent, if you show that you were emailing about it, if you show you were compassionate in the process, I love that case. No matter how crazy it is, what the person presents to you. And right, people present pretty crazy situations sometimes, and you're like, I did not see this coming. There was a case recently that I saw a headline about where someone had requested, oh, I need to be transferred to a different supervisor under the ADA because, you know, this one's causing me all these medical problems, which sounds like a great accommodation. I wish I could do that like every 3 weeks. But oh, I forgot they're video recording this. I hope no one looks from my office, but that's okay. So, you know, the court went through, and we got to look at those situations and really, again, roll up our sleeves and say, why are you asking for this? What's the real reason? And a lot of times, it's not necessarily disability related so much as they have a problem with a personnel issue. And if you can get down to that and drill down to that, the point, it's not about the disability anymore or whether it's permanent or not. That's another way that we can say, hey, I'm not really seeing this as so much of an ADA situation, so much as a personnel issue, but whatever. What can we do about it to make this work? We're not going to transfer you, but what else would work, right? So does that answer your question, though, about permanent versus non? That's a great question. How does this all play in with workers' comp and someone who is gone, and whether or not you bring them back to work after an injury or whether you do not? And you've got to remember that despite our obligations under workers' comp, people also have rights under the ADA. So you've got to look at whether or not certain accommodations would be reasonable for someone totally aside from the workers' comp situation. I would encourage you to treat workers' comp accommodations the same as any other type of accommodation. You know, this is another big issue that we see, and this is something the EEOC is going after you on, right, for good reason. They've noticed that a lot of us are really, really well trained on workers' comp issues. And so we say we provide light duty for workers' comp. We give 80 days, and then after that, we don't provide light duty anymore. Well, what about the ADA? We need to consider that. If you're providing light duty, you can't just say, oh, there's a hard stop to it. You've got to go through that analysis for each particular employee. Do they need some sort of job modification that will allow them to do their job in some way with accommodations? That could be some sort of lighter work, but think outside the box. Don't just think in light duty terms. Think about what's a reasonable accommodation and what's not. Permanent light duty, I hope, isn't in any job, right? Because there's not going to be that. It's not going to be available. You're not gonna, unless you really have that kind of work. In a lot of situations, that's not going to be an option. But you need to think about what are the other accommodations that we could offer that would make this workplace accessible to this employee. So really, whenever you've got that workers' comp situation, I don't want you to be driven by, oh, this is what workers' comp, what we usually do. In the back of your head, I also want you to be thinking, this is what the ADA probably requires us to be thinking about here, regardless of whether this was an on-the-job injury or not. You got to be asking yourself, what's a reasonable accommodation and what's not? And I see too many cases. And again, I say the EEOC is going after people for good reason, because they'll say, oh, we only offer light duty for 80 days. And they say, well, this person needed X, Y, and Z for 2 or 3 weeks. And you're telling me that for this giant organization, that would have been unreasonable? Explain why, right? And so we need to go through that analysis every time to make sure that we're both recognizing and honoring people's rights under the workers' comp statute, under state law, but also under the ADA and MHRA. By the way, I didn't talk about applicability of these laws, but ADA, if you have 15 or more employees, you're subject to that. MHRA, which has basically the same requirements as the ADA in many respects, is if you have 6 or more employees in your organization. So keep those numbers in mind as you think about what you need to comply with. Can we talk a little bit more about marijuana? I don't think we've had enough marijuana this morning, or conversation about it. If you've had marijuana this morning, that's your own problem. But you've already gotten a good talk about what Missouri Amendment 2 did. It decriminalized the use of medical marijuana for registered card holders at the state level. And I love that when Jay talked, he emphasized to you, does this make marijuana legal in the United States when a state passes a law like this? Yes or no? Yay, good. All right, we're all done, thanks, no. So that's really important and something we need to consider as we think about how it's going to affect our workplace, which I'm going to talk about for a few minutes, and then I'll open up for a few more questions again about how you're going to deal with this in your particular workplace and what your concerns are about it. So again, people are going to be allowed to use marijuana for medical reasons in the state of Missouri, and the state of Missouri isn't going to criminalize that. The federal government still, of course, does. So the situation that we're worried about, or concerned about, or want to be ready for is the one where an employee comes to you, and somehow, one way or another, you gather that this employee is using marijuana for a medical reason, and then you need to figure out, what are we going to do about this? And the first step before this happens is figuring out what your drug testing policy is going to say, not just about marijuana, but about drugs generally. Really think about what you care about. Jay kind of alluded to this, but I've seen it too, where a lot of employers are saying, we really don't care about marijuana or other drugs even for this particular position or that particular position. Or we don't care about marijuana, but we do care about other drugs. That's a decision that you have to think about and make, and one of the biggest reasons is because we have had sustained, historically low unemployment rates in this country. Do you want to exclude an entire class of applicants as I learned this morning from Jay, up to 5% of our state potentially, because you want to have a totally marijuana-free workplace as far as how people are using it. So let's think about what you want policy to say on this and what you want to test on when you send people for those drug tests. I'm not a drug testing expert, but the basics are you have decisions to make. Are you going to do a pre-hire drug test? Are you going to do a reasonable suspicion test? Are you going to do post-accident testing? And are you going to do random testing? And you basically have the option of picking which combination of those you think is right for your particular organization. Now, I agree with what Jay told you earlier about what we think the rules probably are going to be as courts come down on this. Now, the other thing I agree with is that we don't know a lot yet because it's going to take years and years for these things to be worked out by who? Judges, juries, you guys, us, sitting on juries are going to decide what the law is here. But what I try to do in working clients through the situation of people who bring marijuana issues to work, so to speak, is make sure that you are not the test case, while also meeting the obligations of your business. I would love it if you are the test case. I would love to be one of the million lawyers in this country that gets to try the first marijuana-related workplace case. I don't want you to have to go through that because it's a lot more fun for me and no fun for you. So what are the general things that we are saying we think are going to be allowed and not allowed? Generally, pretty much everybody agrees. Possession at work, having the gummy bears, brownies, or whatever, I don't know how else you take the marijuanas, but like however it works, can't have it at work, right? It's still an illegal drug. You can all tell I do not use marijuana based on how I just said that. But possession at work, something we know pretty sure and can be pretty comfortable with, we don't have to tolerate. Use at work, we start getting into a bit of a gray area, but I still tend to say that it is an illegal drug. Bringing this to our property, using it on our property is not something that we want to allow, and certainly impairment at work I see as something that you don't have to tolerate. If someone is sitting there eating Cheetos and laughing at their YouTube videos, whether they're high or not, it's not something that they should be doing, right? So that's generally what I think, where what our rights are as businesses about what we have to allow, but what we don't have to allow. So the question is, what do we have to allow under the ADA? And I do appreciate that Jay didn't answer this question too much because it literally was like the only thing I was going to talk about. So I kept like sweating a little bit, like, oh man, I might like not have to present on anything because he's going to answer it. But so this is something I've been working through clients with in a couple different areas. What happens when you find out through a drug test or otherwise that someone is using marijuana for a medical purpose? Now, number one, your drug testing policy can have a provision that says if you are using a medication that is going to cause a positive test, you need to tell us that up front. We need to know that because it could be an issue for our workplace. But generally under the ADA, the very, very general rule is that illegal drug use and substance abuse isn't something that we've had to allow as a reasonable accommodation. Now remember, you've got different state laws here too. The MHRA is very undefined. It doesn't have the same regulatory scheme as the ADA, so what's allowed and what's not is a lot more amorphous for Missouri employers. There are recovering addict provisions in the ADA. So someone changes their status when they go from a drug user to someone who is recovering from drug use. At that point, the ADA kicks in, and what they're experiencing as a recovering addict, we know, could be a medical condition that substantially limits their life, right? Maybe they can't do the job at all for a week because they're in rehab and they're recovering. That could be something that triggers ADA protections after they're done using. There's a really fine line there, but a really important line between a current user of drugs and someone who uses it later. But here's what I really want us to consider is whether we have to, clients always ask, and you all were probably wondering, do we have to accommodate I'm using that in quotes, someone using marijuana for under the ADA? Does it require us to accommodate that? Well, that's really not what you're accommodating. Not to criticize you for the question that you're thinking about, but that's not really how we should phrase it. The question that we have to ask ourselves is it a reasonable accommodation to make an exception to our usual drug testing policies and practices for a person who tests or is going to test positive under our drug testing, or for someone who's using it off-site? So I tend to think that when someone presents you with that issue, right, that question of they're using marijuana outside of work, they're taking the gummy bears for some pain or something like that. There are a lot of good reasons to take it, perhaps. When someone's doing that, what is our obligation to them? Well, you have two, as with anything in the workplace, there are multiple roads you can go down. One road you could go down is to say, you know what? It's an illegal drug. The federal government of the United States of America says this is a crime. We're not going to tolerate having someone in this workplace who commits crimes. So if you're going to commit that crime, you're no longer going to work here, right? Whether it's a medical condition or not, we don't care. We're following what the federal government says. Okay. What's the risk to that? Just ask an employer in, I believe it was Connecticut, that got sued under Connecticut state law, not federal. And the court went through the case, and that's exactly what happened. They said, look, this is a illegal drug. We're not going to accommodate it, even though Connecticut says you can use it for medical purposes. What the court said was, look, you had a duty to engage in that interactive process to try to find some sort of accommodation that would allow that person to keep working. And looking at your communications, we don't really see that you went through that. We don't really see that you tried to talk to the person about options. We don't really see that you tried to evaluate how this was going to affect the essential functions of their position. So as a result of that, we think the employee gets a trial on this. And you can go tell a jury why you didn't accommodate it. Again, fun for me, no fun for you. So the question is, when someone brings that to us, what's maybe a safer route than just saying, oh, drugs, you're fired? Which maybe you have a right to do. Honestly, I don't know yet. That's for a jury to decide later on in Missouri, years from now. When I'm walking clients through this, I say, okay, let's look at this particular position and see, would it be a reasonable accommodation in this particular position for you to tolerate that someone is going to test negative for drugs every now and then? And again, I want to make clear, we are not tolerating that they're impaired at work, and I don't think we have to tolerate that they use at work. We probably have a very interesting discussion about that. Maybe. Oh, okay, good. Jay says he had the same slide as me, so we're good. We don't have to litigate this one. But it's amazing because I've seen presentations too, and really more experts who focus just on this talk about it, and they give slightly different advice than me, and I'm like, oh man, maybe I should be thinking about this. Because I've developed my advice on this over the years as I've seen that, and as I've actually started litigating this with the EEOC and in state agencies. So I've had this issue already come up in litigation. So what we need to be thinking about is how do we engage in the interactive process with someone who tells you that? And I think the first question that we need to ask ourselves is this a safety-sensitive position? Because that changes the calculus. Anybody in here who's DOT regulated? It's easy for you. Oh, wow, a bunch of you. Department of Transportation, what do they say about marijuana? Nope. They are not a fan, right? They don't want any risk that someone gets behind the wheel when I'm driving back on 44 and is high, and frankly, I'm very glad for that, right? So they say, you have to follow our drug testing procedures. There's no exception for ADA. So if you have a DOT-regulated employee who comes to you, it's easy to say, look, this is a safety-sensitive position covered by the DOT, and this is what the DOT says about it. So we have to follow our drug testing procedures here. Now, if it's not a DOT-regulated position, but it is safety-sensitive, you need to confirm it's safety-sensitive. Remember the essential functions? You need to look through and think, what is this person working around? What are the consequences of potential impairment, right? And I say potential impairment because you're never going to tolerate impairment. If you see the signs of impairment, you investigate that. You send for the drug test. You do everything else that you need to do to confirm whether it's impairment or not. But You want to make sure that you're thinking about, is someone's off-site use actually going to affect them at work? And so even when they're in a safety-sensitive position, at times I've gone ahead and said, if you want to, a safe route would be, let's engage in that interactive process with the doctor and with the employee. And let's figure out what the doctor says about this, when it's being used, how it's being used, and how it's going to affect the employee after use, and for how long, to decide, is this going to cause impairment at work based on all the information that we can get. And you know what? I'm saying treat this potentially, one of your options is, treat this just like any other impairing drug. You know what? This is an easy problem because we've had this problem forever. There have always been drugs that people take that impair us, as anyone who has had surgery knows and doesn't remember the next 3 days, right? We've always had this problem. So you need to ask yourself, is the way this drug being used going to affect our workplace, and how? So even with safety-sensitive positions, I sometimes say, okay, this employee is saying they need to use medical marijuana. Talk to them, listen, and write down, or have them write down if you want to, exactly how and when it's being used and for what, right? So that you can start getting an idea of how it might cause impairment at work. So someone who takes it after work at 5 p.m. and then nods off and then comes back to work the next day, I'm probably not as concerned that it's still causing impairment after they sleep, right? Someone taking it 8 a.m. before they come to work, that's a big concern. So you get that information from the employee. But then again, this is probably an invisible disability. It might be pain, it might be Crohn's, it might be a lot of different things. It might be back pain that's really severe, right? Anyone who has back pain in here knows that you're probably not happy sitting in that chair after a while, right? You need to get up and move around. So you've got to think about when is the employee taking it, and then continue through the reasonable accommodation process that you should follow, which I mentioned earlier. What's the next step? Engaging in that discussion with the doctor in writing. And this is the part that can be really, really hard, and that when I'm working with clients, I hold their hand through it and write down the communications myself often and work with them on what they think is appropriate, because I think in these situations, look, I've got a great accommodation form. I can send it to you. It's going to do nothing for you in this situation, right? Because it's got really generalized questions. I'm all about trying to come up with like 3 to 5 questions, if we can, for that doctor that's going to help us make the decision about whether this person can continue working in this position, right? So I'm asking that doctor, when is the employee using it? How much? Are they always going to use it in that way and in that time? And how long is it going to affect the employee after that? Their schedule is this. Will it ever cause impairment at work? Go ahead and ask. See what the doctor says about that. Often, as Jay said, doctors are really squirrely about this right now because they're not supposed to be telling people, take an illegal drug that we don't have enough research on yet for me to really prescribe. They're not going to say it's prescribed. I haven't seen a doctor say that yet because they can't. They can't prescribe it. But they can say, okay, I'm certifying why the employee is using it or what the condition is. That helps. We're going to ask what the condition is or what the nature of it, of the disability is and what the impairment is, so we can confirm this is because of something that might be a disabling condition. We're going to try to confirm that it substantially limits a major life activity in those doctor's forms. I haven't seen a doctor that says no yet, so they're going to get past those 2 questions. But then the next one is really emphasizing to that doctor, can you guarantee me this person will be never impaired at work based on how they use it? Especially for those safety-sensitive positions. And that's a safer route to go than just saying denied. It's a safer route to consider it, even if at the end of that path, you get down to the end of it and you say, you know what, because of this, that, and the other reason, we're not convinced. We're not sure that this is really going to be as safe as we'd like it to be. And this is a really important position that it be safe, right? Then that's the situation where you might say, given what we've got, we can't say that we're comfortable with you performing the essential functions of this position. So as a result of that, we're not comfortable granting an exception from our drug testing policy. We're going to follow our regular policy and we feel confident in that decision because we've started engaging in that discussion with you. But remember, again, and I don't mean to be a broken record, but this is where I see the problem happen. The problem happens when we stop the conversation there. When we say at that point, we're done, we're not working with you anymore. We've denied your accommodation, so you no longer work here. No. After that, we explore potential other accommodations. And again, what are the last two we look at? A period of leave, which often actually can help people. Their doctor says, you know what, yeah, taking time off work would be better for them. Or number two, transferring them to a vacant position where we're more comfortable with them returning a positive drug screen, right? So those are safer routes to take, no matter how you feel about these drugs in the world and whatever they are. If you want to be that test case where you just fire anybody whoever returns a positive test, I would love to be your lawyer. It'd be a lot of fun for me. But again, we don't know how that's going to turn out for you. The safer route, potentially, and again, this is all situation dependent, but a safer route, potentially, is to say, look, we need to really look at this, and we need to get your doctor's input on this, maybe multiple doctors' inputs on it. We need to figure out if this is a reasonable accommodation to make that exception to our usual drug testing policies and practices, which we thought about before this because Andrew told us to at a Connell insurance seminar. So that's what we really have to be thinking about in the process. But to put a bow on it, use your regular process. Go through the same analysis that you do with any other sort of accommodation in the workplace. Get what the accommodation is that the employee wants. Decide whether you need to get a medical certification, potentially explore other accommodations if they would work better for you, and then decide on what's reasonable and what's not, and set the parameters for that employee, if it's a difficult accommodation, in writing, and maybe even let them know, hey, we're going to try this out for a couple of weeks to see if it works for us, but we're not sure, but we want to give it a chance, right? That's what the interactive process is all about. And often, I think that's a good idea, especially if this next slide is what I thought it was, dogs, right? Dogs are potentially an accommodation under the ADA, and this is one that we're seeing a lot. We have a whole group of people now at my firm focusing on accommodations like this, advising employers on them and dealing with litigation when employers say, no, you cannot have a dog in this workplace. Come on, right? This is a potential accommodation that we need to grant in our workplaces and consider when people need it. So you need to go through that same analysis on the last slide, no matter what the accommodation is that the employee is asking for. What's really important about the ADA, one, yeah, everyone worries about the final decision. Are we going to grant? I'll put the dogs back up. I can see people like that. What we really need to worry about isn't so much just the final decision, but the process and road that we use to get there. I've said the words interactive process a couple times. That's because those are the words in the EEOC regulations implementing the Americans with Disabilities Act. It requires us to take the lead, to roll up our sleeves, and have a really candid, robust, and frequent discussion with people about what a reasonable accommodation would be. So, as a result of that, you, as the people trained on this, as HR, as business owners covered by the MHRA and or the ADA, have to make sure that you're taking the lead and taking control in that discussion, staying on top of it, being firm with what expectations are, but being empathetic. I told you earlier, I've got some phrases that I use. I think they're in these slides somewhere. I can send to you, but where that I put very often in communications like these, and especially in ones where someone can't work anymore, because they had just an awful accident and there's no way it's going to work out in their particular position or maybe in any other position, I'm usually writing in the last paragraph, my heart goes out to you. If it's someone comfortable saying, I say, we're praying for you. Like, show your empathy. Why? Because remember the second half of my job, if we're defending that decision in court, I want to be able to put that up on the screen for the jury and say, this is not an employer that discriminates, right? I know you're not. And one thing I worry about is that we overtrain HR and make you so worried sometimes that you're not going to step up, get out of your shell, and communicate the way that we should with people in this world. You need to do that. I see all too often when I'm doing electronic review of emails, an employee will send a complaint or accommodation request, and we get squirrely, right? We get really, really nervous about it, and there's never any response from us. And sometimes it's because you had an in-person conversation, right? I always want to see a response to that email, whether it's to say, hey, I'm really thinking about this. I want to give you a call tomorrow and talk about it, right? I want you to document that you went through that step, what you're thinking in your head, the empathy that you're thinking. If you have some concerns, go ahead and put the employee on notice of that. I'm thinking about this email, but have some concerns about a few things you say. I want to keep thinking about it a little bit. Can we talk about it tomorrow? That's what you're thinking, and that's the truth. But instead, what I see is no response. And think about how that's going to play out in court. Someone requests an accommodation in an email, or says there's a problem with their accommodation, or complains about something and says it's medical related, and there's no response. What's going to happen 7 years later? You're going to say, I'm pretty sure I talked to this employee about it. Oh, great. We'll tell the jury we're pretty sure about things, right? I'm a great lawyer if I'm telling, oh, my client's like pretty sure they didn't discriminate, like 99-ish, maybe. So I want that response because I don't want the other lawyer to hold it up in his opening statement and say, look, my client requested an accommodation, and what did this employer do? Nothing. This employee is going to take the stand. He's going to testify later today, and he's going to tell you, he sent this email, he requested this accommodation, and what did the employer do? He doesn't recall any response ever from this employee. Right? That's what the attorney's going to say. And maybe that's true. The person probably doesn't remember any response because it's years later. Right? And you're telling me, no, I did respond. Well, let's just prove it. Put in a little email, hey, it was great talking to you today. I'm going to keep thinking about these things. Let's talk about it again tomorrow. Putting in that time. I know it's time. I know you're busy. I know you have other stuff to do. But the process is what's important. You know, when it's interesting trying a couple jury cases, how they both very much care about the law. Anybody here been on a jury? Oh, not enough. It's a lot of fun. So, but they often read the instructions that the judge gives them back in there and they actually say, okay, we need to follow this and do this. They're really good about that. But they also make a lot of decisions in these human resources cases based on empathy. In cases where I win, I always go talk to the jurors that vote against my client and say, hey, like, what was the deal? Like, what didn't you like? And very often they say, you know, HR just didn't seem really involved. They just didn't seem to roll up their sleeves. And that's why I started telling people this in presentations, is because I'm seeing jurors, when they vote against us, say, you know, I don't think they really cared about this person. I don't think they were empathetic. I'm like, yeah, but do you think they discriminated or retaliated against? Well, I don't know. Like, you voted against us. What are you talking about? Right? So going through this process, I'm coming at it from that perspective that I don't want you to be thinking about day to day. Most of you in this room, maybe all but one of you, will never have to sit on a stand with me asking you questions to explain what it is that you did and why you did it. It's just not going to happen. But the advice that I'm giving you and the things that I'm suggesting are intended to help you so that you are set up. So any attorney looking at the case from the other side, from the employee's perspective, is going to say, oh, wow, these people were on top of it. These are very, very likable people. I can see that from documents before I even take their deposition. Maybe I don't want to be working on this case, right? So that it becomes one of the 99% that for one reason or another doesn't go to trial. That's why this stuff is important. So with service animals, go through that same analysis of, is this a necessary accommodation based on a medical condition, based on what the doctor's telling you? What does the doctor say about it in response to a customized questionnaire that goes through the key elements of the ADA? And are there any other accommodations? Do we need to change the way that things are done? Is it safe to have a dog in the particular area where the employee wants to have it, right? So those are all the kind of considerations that I want to make sure you're going through and that you're documenting so that we can explain to a jury why we wouldn't let a cute puppy in the office. That's also not a case that I necessarily want to try, right? So, because everybody loves dogs. So those are really the big ADA things that I wanted to make sure I wanted to cover. And we've already talked way too much. We don't have too much time left. So I do want to give you all a bit more of an option to ask some questions, and I think maybe we have one in the back. So the question is, what doctor do we talk to that is going to tell us whether or not this employee can be using medical marijuana? And generally in any sort of accommodation situation, the doctor that I say to start with is the one that the employee is using. Right? Let's go ahead and start there. And very rarely do I ever say we need to send someone to another doctor for second opinions under the FMLA or the ADA, even though there are provisions for that. If you go down that road, it's going to take time. It's going to take resources. I generally say let's start with whoever the employee presented you with. Start there and press that person. Say, hey, we have 5 really, really important questions. And I get, I mean, what's the right word? Visual or graphic about it even. This person is working around an open saw. If they fell, it could cause injury or death. Are you telling me this person will never be impaired anywhere near that saw? And why do you know that? Like, make them take that burden. And if they don't take that burden, then it's easy for you to come to that decision that says, you know what, I don't think it's reasonable. I don't have enough to be sure. Now, this can be challenging. Again, doctors want to do the right thing for their patients, and I'm glad that they do, right? There are people out there, there are people in this room, all of us, that need stuff medically, and I'm glad we have doctors that stand up for us. But very often, we all know that that means that what the doctor is going to write down is what the employee is saying is the medical need, because that's part of the legitimate analysis that a doctor has to do. And no doctor or lawyer or anyone else wants bad Yelp reviews because they say, oh, I know, patient, you're saying you need a wheelchair, but I don't think so. Get on your feet, right? That's not going to happen for good reason. So often, if I'm getting back a vague doctor's note, or say you send my ADA accommodation forms and the doctor just sends back a little scribble on a pad, I say no. We need these answers to these questions, and we need it for specific reasons. So that's a great question. Often I say let's start with the employee's doctor, and rarely, if ever, go beyond that. Another one, maybe?
My question is, with pets allowed at work, what do you do about coworkers that are allergic to dogs or cats?
Yeah. First of all, I love that you're open to the idea of my cats in your workplace. We can talk more about that later. Yeah, so the question, what do we do about coworkers who are allergic? That is one factor that is going to play into the reasonable accommodation analysis, right? You're going to take into account everything you're presented with. And you got to look into it. I know, I'm putting work on your plate, and I know you're already too busy, right? But you're going to ask, are people allergic? Are people scared of dogs? Are there issues? Is there issues with the work environment? Frankly, if I'm getting wheeled in for surgery and they're putting the mask over my face, I don't want to look over and see, like, you know, like Air Bud sitting there. Like, not cool, right? Like, so it's going to depend on all those factors. And the biggest thing that I see, again, is my concern that we cut off that interactive process too early. You know, maybe an employer will say, well, you know, we got a ton of people here. Somebody's going to be allergic. We can't have the dog. You sure? Have we looked? Have we asked? Where does this person work? What do the people around them say about this? Are they okay with it, or are they not? Is there somewhere else where we could move this employee where they won't be any more in proximity to the person who has an allergy? I want you to document that you've considered all these things, that you've talked about it with the managers, and that you've talked about it with the employee. The interactive process really has 3 parties: you and the other managers you work with, the employee, and their doctor. And you need to be having honest conversations with them about all these things. Hey, I'm worried about having this dog here because so-and-so or someone is allergic near you, and I'm worried that it could cause an allergic reaction. Well, you know, it's easy for you to say, okay, well, I think that that's not going to work then, and say no. Make the employees make that decision. Pass it back to the employee and say, you know, I would love to grant this, but I'm having this problem with it. and I can't come up with the solution. Can you think of anything? And if the employee says, no, I can't think of anything either, then you just got the best backup that you could possibly have to make a decision that you're not going to grant that accommodation. And again, I think we're worried and we clam up. We're afraid to have those conversations. But in these situations, that's what wins cases. That's what juries want to see. They want to see that you engaged in that process and that you were at least open to it and that you considered what else you could potentially do, moving people to other floors, and then potentially under the ADA, trying it out, just seeing if it works, saying, hey, this is new for us, this is a little different, we're going to see if it works for a couple weeks, and if it doesn't, if employee morale goes out the door, if someone's allergic, if some other problem comes up, if this dog is unruly, then we might change our mind on this, making that up front. And I would write something in an email or some kind of document saying, hey, this is what we're going to try to do. We're going to check back on this because we have some concerns about it, but we're willing to try. But this might not be a permanent thing. We're going to see how it works. So that's what I would say to do in a situation like that. Heather, have you found somebody else who has a question, or we?
I say we move. I know we really want to get to FMLA. We have about 20 minutes left of presentation time, so I say we table and move on and make sure we get to all the content.
So, I get two complaints when I do presentations. One is like you'll complain about the food as if like I was back there cooking it and like I wasn't back there like making the bacon. It's not my fault. This was really good this morning, but the other problem is I don't get through all the content. I got nowhere to be tonight. I will stay here afterwards if you want to talk to me. Come up after. But I want to make sure, too, when we talked about, Heather and I talked about different topics to cover, FMLA remains one of the big ones that we need to make sure that we are complying with and knowing the ins and outs of. And here's some of the important issues that I'm seeing under the FMLA. Number one, your managers aren't trained on it. We're getting more and more clients asking us for FMLA training. So we've developed it, and we're selling that because we need to train our managers that when they see someone who has a potentially serious health condition under the FMLA, we have to give them that notice of eligibility within 5 days. That is probably the most violated rule in all the employment laws on the books. When your managers see that someone has something that could be a serious health condition, which has its own definition, right, of being off for 2 days of work or and certain inpatient treatment, right? If someone has that, we have an obligation within 5 days to give them that notice, which you can get on the DOL website, that explains whether or not they are eligible for FMLA. Doesn't mean they're going to get it. It explains whether they meet the 3 criteria for eligibility, which are they work at a work site with 75 workers within a 50-mile radius. They've worked 1,250 hours in the past year, and they've worked for you for 1 year. That's all the notice of eligibility tells them. After that, they have the obligation to get you the information about their health condition so that you can decide whether to designate it as FMLA. Once you get the forms or the medical certification from the doctor requesting FMLA, again, these are all DOL forms, they're out there on the internet. Once you get that information about the person's health condition, you have 5 days to tell them whether or not their absence is protected under the FMLA. So you've got some tight deadlines there. The biggest one that I worry about is we're not giving people that notice. Is it illegal to not give the notice? No, but it can be a problem in lawsuits, right? Because people say, oh, they didn't give me FMLA, they just fired me, and they never gave me notice. Doesn't look good, doesn't help us, and can lead to violations. Certainly something the DOL does not want to see. But the biggest thing is that your managers are your eyes and ears. They're the ones with the obligations to give that notice. You need to make sure that you are emphasizing to their managers. Someone's going out for a couple days. Someone's in surgery. You give the notice of eligibility. Whether or not you're just going to give it to them and not worry about FMLA, if they've got PTO, you give the notice of eligibility, right? And if you're using a third-party provider, you've got to make sure that they're doing that if that's their obligation as you've worked it out. Heather and I were emailing about a really interesting opinion letter that came down about how FMLA interacts with your regular PTO policies. Kind of a niche situation that might not come up for all of you, but interesting to see how these things are developing. In this opinion letter that came out from the DOL, the employer, what they were doing was, if someone had PTO, what they were saying was, hey, we're going to delay designating your leave as FMLA qualifying because employees would prefer to just take PTO for a while, right? But the thing is, once you get that medical certification from the employee, you have the obligation to do the designation. You can't just delay it and say, okay, these first 10 days will be PTO, and then after that you get FMLA. They either have to run concurrently, which you have to put in your policies if you're going to do, or they save their PTO till later and you don't make them exhausted. So what the DOL said was here, you cannot delay designating. You've got to move forward with that designation process and not just say, oh, well, you've got PTO, we won't worry about this. You can use FMLA later if you need it. No, you want to stay on top of those obligations. Who's covered by the FMLA? I hear a lot of you are public organizations. Is that right? No? Yes? Okay. Yeah, okay, thank you. All right, just make sure people are awake. Maybe you had, don't take those marijuana brownies early, okay? Like they're not, here yet. Like you got to wait until, whenever it's loud. So, public employers, remember, you're going to be covered by the FMLA, but you still go through the analysis of whether someone qualifies as an eligible employee, meeting those 3 criteria, and they might not. You might have 0 eligible employees at your particular location because you don't have 50 employees within a 75-mile radius, and people aren't actually going to be eligible. You still have to get, it's a weird situation, but you still have to give them their notice rights. You still have to notify them that, hey, we are a covered employer under the FMLA, but it's this anomalous situation where they're never actually going to get FMLA leave if they're not eligible employees meeting those 3 requirements I said earlier. Probably some small businesses in here too, I imagine. If you have fewer than 50 employees, should you be giving people FMLA leave? No. If you want to give them 12 weeks off a year for the same conditions as FMLA, that's absolutely fine. But you don't want to go through the same process as the FMLA because you don't want those employees to have the misperception that they are covered employers under the covered employees and that you are a covered employer under the FMLA. Say you have 20 employees and you start giving leave and you call it FMLA leave. That could be a problem. That could give employees rights under the FMLA and make you a covered employer under the FMLA, which means what? You can suddenly be sued for violations of the FMLA. If someone needs time off and it's a reasonable accommodation to give it to them, or you want to give it to them for whatever reason, yes, you have every right to say you can have that time off. But we're not going to call it FMLA leave for you smaller employers because you are not covered by the FMLA. So again, supervisors are the key to step 1. And you need to consider that. There was another really interesting opinion letter that came down about whether an employer violated the FMLA because the management never gave her notice that her absences could have been FMLA protected. She was taking time off to go to a series of IEP meetings for her child, right? And the court looked at what the FMLA actually says. It's not just for serious health conditions. It's for taking care of the serious health conditions of others and for establishing changes in care for other people. So they said, look, those IEP meetings are essentially changes in care for someone who has a serious health condition. You had an obligation to give that person their notice of rights under the FMLA. And this is why I've started saying training on FMLA is something that's key, and it's something that you can do. You can go online and you can see what the reasons are why people are taking FMLA, what constitutes a serious health condition, and say to supervisors, if you see someone has been in inpatient care, if someone's gone for 3 more days, that might be a situation where they have rights under the FMLA and you have an obligation, if you see any of these things, to make sure that you notify them. And I give that example of the IEP meetings because I can imagine that in a lot of your organizations, maybe all of them, Not many people would see that as an FMLA triggering event, right? But it is. That's what this opinion letter said. It really went through what the reasons are you can take FMLA for and said, yeah, the employer had an obligation there to give that notice of eligibility and even to designate it as protected FMLA leave because it qualified. Now, one thing I want to make sure, I kind of want to go to a question we had earlier about misuse of these laws. We know that happens. And so, some people call, the actual name for it is the Family and Medical Leave Act. I have some clients who will call me and say, Andrew, I got another situation where someone's treating it as the Friday-Monday Leave Act. And look, I'm all about flexible workplaces. I'm all about working from home personally, which I prefer to call laundry day. Suddenly, I worked from home yesterday. Magically, all the leaves disappeared from my lawn. It was great. And I'm on the phone with clients, and they're like, "What's that in the background?" It's my leaf blower. I'm like, "You can't hear me?" No. So you need to make sure that you're asking the right questions when an employee is taking time off, and the medical certifications that the DOL provides are a great vehicle to do that. Having the doctor fill those out and certify the medical need is something that you should do. Some employers are having their employees essentially sign statements now too that, again, really certify, like under oath, and say, I'm not going on vacation. I'm not going to go to Vegas. Because there have been situations, believe it or not, where people go on Facebook. Facebook is like the downfall of everyone in this world, but like, oh man, I forgot this is recorded. Strike that. I didn't say that. That was an audience member who said that. So we see photos of somebody on a cruise. Well, what if it's this situation? An employee is on FMLA leave. You see pictures in Vegas. They come back and you fire them the next day. Legal or illegal? We don't know yet. I know you all said illegal because like you thought that's where I was going. But it really depends. What if I told you that that person was on FMLA leave and went to Vegas because her mom, who was in hospice, won a final trip from an organization that gives those, and she chose Vegas? Does that change your answer? This was a real case. It happened. An employer saw that, had the knee-jerk reaction, and said, no, can't take FMLA for Vegas, and fired her. And only found out later it was because she went to Vegas to take care of her mom, who was in hospice care. Do you think I want to defend that case? Please don't make me. I mean, like, I'm all about building business. I'm sure Jay is too. You can call either of us if you want us to, but I would just rather you not get to that point. Asking the right questions is what's going to allow it. Certify the leave. Get that medical certification. If it's intermittent leave in particular, you can get recertification. If people are using leave inconsistently with what you expected them to do, if it's becoming the Friday-Monday Leave Act, you can send a note to the doctor and say, is this consistent with how this employee is supposed to be using their leave? Setting those clear expectations. What are the call-in requirements? It's not going to be call in 30 minutes after your shift starts, right? You need to write that out in your policy, though. And I have to develop it for each different client, but giving people on FMLA a plain language sheet of, hey, you're on FMLA, we respect that. Here's the expectations while you are gone. To make sure that you meet. I think that's a really good idea, especially for bigger organizations where there's going to be a lot of questions. Ask the, employee's physician to confirm that a pattern of absences is consistent with the employee's need for FMLA. And again, sending them, literally you'll send what the absences were. The person was gone on this Friday, this Monday, this Friday, this Monday. Is that consistent with why the employee needs leave medically? Can you tell me, doctor, that this person needed that time off due to their condition? So the last section that I have here, I've kind of been talking about throughout, and I'm coming down to my final few minutes here, and the last thing I ever want to do is be between anyone and lunch. The last section I have here is on workplace communication, and it's not really legal in a lot of ways, and I'm happy to send these slides to people. But the important thing to remember is that none of your communications, texts, emails, anything are confidential, and that when you're in a lawsuit, Good lawyers are going to gather those, and they're going to want to know what people were saying. And often I find those really help our case on the defense and employer side. I find a lot of empathy in emails. I find a lot of empathy in text messages. But I find a lot of things that are misconstrued because we're frustrated with things that happen at work. And we occasionally express that frustration thinking it's going to be private. I would encourage you, as leaders in your workplace, to make sure that people are always being appropriate over these mediums and treating them not as confidential communications, because the reality is that they won't be confidential in a lawsuit. And think about how you communicate empathetically, both with an employee and behind the scenes. And I totally get it. Like, if you're not frustrated by the people you work with sometimes, you are not normal. Maybe you're the one people are frustrated with. I get frustrated at other people I work with. I express that frustration behind their back, in front of their face, whatever. I keep forgetting this is recorded. They're not going to get this far into the presentation. They'll let me go way before this. But the important thing is, if you see something like that, to reset it as a leader in your workplace, to say, hey, I know you said this below, but as we've just discussed, we are not just going to tell this person, no way, we're not giving you that accommodation. We're going to go through this process, and I've learned about it. I'm going to walk you through it. And we're going to make sure that we give this person a fair chance to work in our workplace. Emails that show a lack of animus against people, I use as key evidence in any kind of trial. I mean, it's just so important. And I find it's really, really good. So with that, I'm coming down to my last few seconds. I want to thank you all, and especially thank Heather and Connell Insurance for doing this. It's really special that they do. They don't have to, but it's really important that we all gather together for these discussions and conversations. So thank you all for being a part of it.